Hello, and welcome to Quimbee's CLE course on the California Consumer Privacy Act, Everything You Need to Know. My name is Joe Facciaponte, and I'm a data privacy and cybersecurity lawyer at Davis Wright Tremaine. Prior to being in private practice, I was a federal prosecutor at the U.S. Attorney's Office in Manhattan, where I prosecuted cybercrime and intellectual property theft. Let's begin by talking about what the California Consumer Privacy Act is. It is a law that primarily provides rights to California residents to know how businesses collect, use, and share their personal information. It also gives California residents some limited control on how businesses use and share their personal information and to review, correct, and delete the personal information that the business possesses on them. The CCPA is less comprehensive than the General Data Protection Regulation, GDPR, which is the data privacy law in force in many countries in Europe. Unlike the GDPR, the CCPA contains wide carve-outs for personal information that is collected by certain industries or governed by other data protection schemes, like those that govern the banking, education, and healthcare industries. The CCPA does not, at present, apply comprehensively to employee data. The CCPA contains an enforcement scheme that allows both individuals and a state agency, which right now is the California Attorney General, but soon will be the California Privacy Protection Agency, or CPPA, which will be a new agency, to bring enforcement actions, which can include penalties of up to $7,500 per intentional violation. More on that later. The CCPA is also in a transition period. Substantial amendments to the CCPA, which were passed in 2020 by ballot initiative, will take effect on January 1st, 2023. Finally, the CCPA has spawned copycat legislation in at least 4 other states: Virginia, Colorado, Utah, and Connecticut, which all passed similar but not identical laws, and more are likely on their way. So, how did we get here? Well, something like the CCPA was likely inevitable. On the one hand, the amount of data being used and consumed, including personal data, has increased astronomically over the past 10 years and is expected to continue increasing. For example, according to one survey, the total amount of data collected and used globally increased from 2 zettabytes in 2010 to as many as 181 zettabytes projected for 2025. What is a zettabyte? 1 zettabyte equals 1,000 to the 7th degree bytes, which is 1 byte followed by 21 zeros. In other words, 1 zettabyte is equal to 1 billion terabytes or 1 trillion gigabytes, a truly massive amount of data. Meanwhile, the types of data collected and used by businesses is getting more personal. Detailed purchase histories, biometric information, geolocation information, facial recognition technology, and others means that businesses know a lot more about consumers and their behaviors than they did even just a few years ago. And the growing power of advanced AI and machine learning means that businesses are better able to make sense of this data and draw more accurate profiles about consumers. Yet at the same time, consumers are more open to sharing personal data with big businesses because of the convenience it provides. Everything from smart home devices like Ring and Alexa to Google Maps to fitness trackers. But that means that businesses are now in possession of a comprehensive view into what is going on in consumers' homes and personal lives. Not surprisingly, consumers are also increasingly anxious about data privacy. In one survey, 86% of the respondents said they feel a growing concern about data privacy.